one of our clients built a 7-figure revenue source just from licensing out their trademarks and copyrights. That was the entire, that's a separate revenue source that they created because the brand was doing so well that people wanted to collaborate with him. And he said, okay, I will give you permission, but you need to license from me my brand name and the copyrights. And then that was a 7-figure revenue source. So there's immense power in what you're creating.
Do you have a brilliant product idea, but don't know where to start to get it made? Or are you looking to level up your product, but afraid to take it overseas?
If so, you're in the right place. Hi, I'm Jackie.
And I'm Erin, and we are
the Sourcing Gals,
your trusted guides to everything you need to know about sourcing, manufacturing, and scaling your product overseas. Whether you are just starting out or you've been making your own product for a while, we are here to help women source products overseas without the overwhelm.
In each episode, we'll share insider tips, actionable strategies, and inspiring stories to help you source more effectively, save time, and boost your profits.
Duh!
We know how hard it can be to juggle the ins and outs of product development, but don't worry, we've got your back.
So grab a cup of coffee, get comfy, and let's dive into how you can grow your business,
make more money,
and turn your products into profit. Welcome to the
Sourcing Gals. Now let's get started. High five.
Hi.
Hi, everyone, and welcome back to another episode of
The Sourcing Gals. Today's guest brings incredible expertise in protecting brands and ideas that founders work so hard to create.
She counsels U.S. and international clients on trademarks, copyrights, branding strategies, portfolio management, and much more. She was one of the first attorneys also to successfully obtain federal trademark protection in the cannabis industry.
Named one of the Daily Journal's top women attorneys and a Super Lawyers Rising Star, she holds the distinction of being both a California attorney and a barrister in England and Wales.
We are thrilled to welcome a true expert in intellectual property and business law. Please join us in welcoming Nuzayra Haque to the Sourcing Gals. Okay, full transparency here.
Hi.
Hi, Nuzayra.
Nuzayra saying hello. This is our second go round of this.
Yes, we just spoke to Nuzayra for 45 minutes before we realized that we were not recording.
And she is being so gracious and patient with us that she is sticking around to let us do this again with the button. It's record. I see it. It's recording. The time is going. So I think we're good.
We're great now.
Okay, now we're great.
After I got over that initial oh shit moment.
So thank you, Nuzayra, for being so patient with us as we, we're product people. We're manufacturers. Tech, we're learning it.
We talked about that in a recent podcast too, like doing things that scare you in terms of like us getting into this whole other industry of podcasting and education we're most accomplished in overseas manufacturing. Nonetheless, we have a true expert here with us today. And
Yes.
I was most impressed when we read her intro and talked about her also being a barrister in England and Wales, because I was really curious about the curly white wigs that you see on TV that they wear in the courtrooms in England. And I want you to tell the listeners, is that a real thing?
That's a great question, whether or not barristers have to wear the wigs. So the answer is kind of. When you're in court and depending on your rank as a barrister, you do wear wigs, especially judges, they will wear wigs as well in courts. So that still happens. England is very traditional in preserving their institutions and some practices. And they've carried on these practices for over hundreds of years, and they haven't really changed it, which is kind of nostalgic. It doesn't really serve a practical purpose as such anymore, but it's just something, cool to experience when you're in court, that you do see barristers that are dressed a certain way. There's a black gown, a white wig, but when you're outside the courthouse, you don't really dress that way. You're just then a regular John or regular Joe without the wig.
All right. Well, I always just see it and I think, is that real? Have you ever had to wear one of the white wigs, Nuzayra?
No, I've actually not. I've not had the good fortune of wearing a white wig because
I don't know why it fascinates me.
Because I left England right after I finished my bar there. So I didn't really practice in England. I did the bar, I passed the bar, and then I moved back home to the US. So I didn't really get to go to court and wear those fancy white wigs.
Well, maybe one day.
Yeah. Well, hey, actually, that segues into this next point because we did say there might be some reason why we would have Nuzayra back in England. So let's talk about the very first thing a product-based founder should think about when it comes to legal protection. Because you did have a very interesting point about this when sharing your idea with another person and then how a third country might get involved in this. So let's go back to this because I think it was very interesting. So what would you tell a product-based founder one of the first things they should do for legal protection?
The very first thing that you should do as a product-based business owner is when you are at the concept stage with your product, you're doing the technical designs, you're thinking about your product, how to take it to market, looking for potential investors. No matter who it is that you're speaking to, a potential investor, potential business partner, manufacturer, supplier, you always want to send them an NDA first. You want to have a non-disclosure agreement template ready to go. It should be something that is in a template form, so you don't have to customize it every time you're talking to a new party. And all you need to do is just change the name of the party that you're going to be speaking to, and you want to send them that contract before you disclose any of that information. And what that does is it puts that person on notice that you take your idea seriously, which always makes you look more serious as a business owner, as someone who understands the value of their IP. So it gives them that notice. And also it gives them notice that the confidential information that is about to be shared with them is proprietary. So they need to keep it confidential. They cannot use that information for anything else other than just talking to you and working with you. So if they do end up using it for some other reason, then you can always enforce that NDA against them. So that is one of the first things that you always want to do. The second thing would be that before you spend thousands and thousands of dollars on advertising, marketing, manufacturing, make sure that you do the basics, which is find out if the brand name that you want is available for use. And if it is, trademark it immediately.
So going back to the NDA, something that I've heard from various folks in this industry is always that an NDA doesn't mean anything when you're working with folks who are overseas. And I don't personally believe that. And so I asked you specifically about that. And your response was really enlightening.
Yeah, absolutely. So it is true that NDAs or any contracts for that nature, they are territorial. So you have to be very specific in the jurisdiction and venue clause in an NDA or in any contract. And this jurisdiction and venue clause is present in every contract. And it's one of those boilerplate contract clauses that no one really pays attention to. It's just there, but it's something that is very important, very similar to having a force majeure clause that became very important during COVID, but no one really thinks about those clauses before. So for this specific instance, if you are in a business relationship with someone who's not in the US, then you want to be very specific about the governing law and where the jurisdiction or the venue is going to be for any disputes to be settled. So for example, if you are based in the US and you are getting into manufacturing relationships with companies in China, in Italy, in Spain, you want to be very specific about which country's law will govern that contract, because now you have multiple parties from multiple countries. And you shouldn't assume or sign that any contract that gets sent your way, that this is going to be enforceable in your country. So you want to look at that clause and say, okay, say, for example, you have a manufacturer who's based out of Italy and you are in skincare or in beauty. And you send them an NDA that says, we are going to mutually disclose information, because this is also something important to remember, is that you're disclosing important information related to your business, which is your product idea. But on the other hand, your manufacturers or suppliers might also be disclosing sensitive information to their business to you. For example, their techniques, their processes, their methods. And this has to be shared with you because they want you to understand how they work so that they get your business. So when you send them an NDA, which is saying that this will be governed under California law and the venue to settle any disputes is going to be Los Angeles County, someone sitting in Italy will look at that and think, this is really unfair, because I don't want to be the one who has to go through all of the inconvenience to fly to Los Angeles and fight over this contract if something goes wrong. So what can you do? So when you have countries that are separated by continents, or even just different countries, doesn't even have to be separated by continents, but when you have companies in different parts of the world, and you want to have a jurisdiction and venue clause which is fair and equally inconvenient to both parties, then you can choose a neutral third country, a country that has nothing to do with your business. So I gave an example that it could be the UK. Hong Kong is also a country that is used sparingly, not sparingly, I'm sorry, the opposite of, they're used a lot as a neutral third country where disputes are resolved. So Hong Kong has actually built a reputation for that. They have a lot of international arbitrations that happen there.
I like when you say mutually inconvenient.
Yeah.
Yeah, mutually inconvenience, a funny one.
Yeah. It makes sense, though. Definitely makes sense.
Yeah.
Well, so that's where,
so they're just neutral here.
That's where we think that maybe if, heaven forbid, we get to the point where we have to have any arbitration in England, you'll get to come and we'll get to see you in a white wig.
Yes, for sure.
Yes, it could happen.
I don't know if she's counting down the days. I think we are, just because you'd be living the meeting.
Yes, of course. You mentioned very quickly about a trademark, and we know that NDA is probably one of the very first things when you're just dipping your toe into the world of legal matters for your product-based business. But then you had 4 other really big considerations for these founders. Could you walk us through those?
Yes. So we'll talk about the 4 different types of IPs now. So something that every founder needs to know is that if you have an original brand and you are creating original designs, original products, then you most likely have more than 2 of these intellectual property in your business. So the first one that we're going to talk about is trademarks. Second one is copyrights. Third is patents. And last but not the least will be trade secrets. So
yes,
we'll start off with... Yeah, trade secrets are really, they are a game changer. They help you out in many scenarios where you might not want to actually disclose your inventions or your ideas through registration. So one of the things to understand is when you get any kind of intellectual property registration is that you are making it public. So that is the whole point, that the whole world should be able to search and see who owns a specific brand name, who owns a certain product idea, or who owns the designs, so people can see there's ownership on it and they don't create something that copies it exactly, or that they can create different versions of it and work around it. Or in terms of patents, they can be inspired by what they see and create their very own version. So that's the whole aspect of intellectual property registrations, is that you make it public. So we'll start with trademarks. So trademarks are anything that allows people to identify your brand and to find you. And this is really important because it's the foundation of your brand. So trademarks are names, logos, taglines, unique color, and unique sound. And an example I can give of trademarks that it's in everyone's house is Netflix. So when you turn on Netflix, there's a variety of trademarks that you can see in action. As soon as the TV is turned on and there's that ta-dang sound that happens, you know that Netflix is on. So even if you're not looking at the screen, just by hearing that sound, you know that that's Netflix. And that is a trademark, along with how the font, the big N in red, how that appears on your screen. That's a trademark. Also, how the full words are organized, full word of Netflix, and just without any design elements, just the plain word Netflix is also trademarked. So in a matter of seconds, you get to see multiple trademarks play out when you just turn on Netflix. And another great way of understanding trademarks is that you might have heard people use this word in their sentences when they're referring to something that's iconic or something that is a differentiating factor. So you'll say that, oh, this person says that phrase a lot, that's their trademark. I've heard this piece of music related to this brand, like example, Netflix or BBC, that's their trademark. That's a trademark sound, or that's a trademark thing that someone says. And essentially, that's what it is. It's a source identifier. So that's what a trademark is supposed to do. It's supposed to make your customers feel a certain way when they hear, see, or sense anything related to your brand. So they're able to connect it back to your brand. And that's why trademarks are considered a foundational aspect of your entire brand. Because based on what you get on your trademark search, and if you want to trademark that brand name, based on that, you make the decision of getting your domain name, getting your accounts registered on Amazon, on eBay, on Etsy, wherever it is that you're selling. You're going to use your trademarks on your products, packaging, on the body of the products itself, so it acts as a source identifier and your customers can see it and go, okay, this is from this particular brand. So that's why trademarks are so important. And also from an expense standpoint, like as a business owner, when you are budgeting expenses and what to invest in first, the reason why I always recommend that you start with trademarks is because they truly are the very first thing you need to get clear to even start earning money. So if you don't have your trademarks registered, you might not be able to get on Amazon's brand registry. You need, at the very least, a trademark application number to apply and get on Amazon's brand registry. For a lot of product-based business owners, that is the first platform they use to launch their business or use it as a supplemental platform. And also, if you find out that somebody else owns a trademark and you've spent the time of getting your domains, your account names, your products with that name, now you have to rebrand. And for a lot of businesses, that's just not feasible financially.
Right.
It's very expensive. It can be cost prohibitive. And for some businesses, they've actually just shut down. They've folded the brand like we can't even do business anymore. So it's one of the first things you want to take care of. Trademarks can also protect logos, like I mentioned, and that's a good segue into copyright. So one particular element can have multiple types of intellectual property rights on it. So when it comes to your logos, if your logo has interesting design elements, along with being a source identifier, it's also an original work of art because it has interesting design elements in it. And it could be eligible for copyright protection as well. So copyrights protects anything original that you create. And that extends to literary work, graphics, designs, and designs can mean animation, product design, technical design. It also extends to software codes, to algorithms, to user interface layouts, ranging all the way to online courses, podcasts, audios, videos, choreography, music. So it's very extensive, and copyrights will essentially protect anything that you create that is original to you. And
that's so interesting. I want to jump in and
yeah.
say that in a recent project I worked on, I was very surprised and curious to find out that the project was with Crayola, and all the way down to the exact yellow color of the box and the way that the flap goes in and it curves like that was all part of the copyright of the box. So it was so interesting because when we were doing this project, they were like, oh, well, you can change this, but you can't change that because that's the copyright portion of our box, even down to like which colors were in which order on the front of the box, which is something you wouldn't necessarily know, but it was so interesting.
Yes, copyrights are really very, very cool. There's so much that you can do with copyrights. A lot of the times when I talk to founders and they come to me with a product design, there are times when that product design or that specific software code might not be eligible for patent protection, but it can still be eligible for copyright protection. So it's something that you definitely want to use in your business. And there's very practical reasons why. So one is obviously you want to have a proof of ownership with your registration certificate when you register it, but also because it helps you to actually enforce your right. There's no point of having all these registrations if you can't use them in real life. And registrations are a very important part of that. So something important to note about copyrights is that in the US, under US copyright law, anytime that you put your ideas and thoughts in some tangible form, a copyright is automatically created. So, that question that I get from founders a lot is, how can I protect my idea? And the answer is you cannot actually protect an idea, but you can protect how you execute that idea. The execution and implementation of that idea is what you can protect. Wow. So if you are thinking of a specific song that you've been humming for some time, as soon as you start writing down the melody or the music, a copyright is created. But even though a copyright is automatically created, we are one of the only countries in the world where we also have a registration system for copyrights. So it's easier for creators to claim that ownership and protect their rights. So it's a really, really awesome tool we have that in many countries they don't have this. So it's very difficult for creators to actually assert their rights and not be challenged constantly. And there are many benefits to registering your copyright and having it on that registry. One of them is anybody who is questioning your ownership over your original work can look up the registration certificate to see exactly who the owner is, when was this work created, who was it created by. So all of that information you get on that certificate, which shows the chain of title. And a lot of enforcement actions actually cannot take place without registered copyrights. So something important to note for all online product-based business owners or online business owners, period. If you are creating original work, be it product design, graphics, whatever it is, and you are selling it online, you need to know about the DMCA Act, which is the Digital Millennium Copyright Act. So Digital Millennium Copyright Act is an incredible tool that we have at our disposal to take down infringing content. So if you see that someone is selling your product or selling your online course without your permission and you want to take it down, the best way for you to do that is to submit a DMCA complaint to the hosting platform. So obviously you will send your cease and desist letters to the infringer, but you will also submit this DMCA complaint. And under the DMCA, that hosting platform has a set timeline. The time keeps ticking, and there's a deadline within which they have to investigate and take action and take down that infringing content. So because it's so time sensitive, when you submit a DMCA complaint or you submit an IP violation claim, say to Amazon, to eBay, to Etsy, wherever, the very first thing they ask for is your copyright registration certificate. is your trademark registration certificate. They want to see, do you actually have ownership over these things that you are claiming to have ownership over? And they can't investigate your entire business. There's no time for that. So what they go off of are these registration certificates. And if you cannot present these registration certificates, they're not going to take action because it's too much liability for them. Because if they mistakenly take down a site, say an entire website gets taken down by Google, it's being hosted on Google domains and it gets taken down, then it turns out that that was an error. The person who owned the website is actually the rightful owner. Google can land in some serious legal trouble now for doing that. So a lot of companies just don't take any action.
Interesting.
And on top of that, recently the US Supreme Court came out in a ruling that said majority of copyright lawsuits that you now file has to have a registration. Without registration, we're not filing copyright infringement lawsuits. And there are some exceptions to it, but those exceptions are very, very limited. And the reason is, minus a registration certificate, the courts were in a chaotic state trying to figure out who's the rightful owner. So a registration certificate is your starting point. And I'm going to mention this one last thing, then move on to patents, which I know a lot of people are interested in learning about. So the last thing I'll say is, when you have registrations overall for any types of IP, you have a lot of leverage when it comes to your legal fees. And that is important from a strategic standpoint. When you have registrations, you can actually recover your attorney's fees from the other side if you sue someone for infringement and you end up winning. So if you're a small business owner and you don't have the legal funds to spend upwards of 6 figures, because that's how much sometimes it costs, not sometimes, most of the time, that's how much it costs in infringement lawsuits. If you have, these things are expensive because you have to hire experts. You have to hire all of these different experts that come in from different industry backgrounds to testify about similarity. It's a whole thing. So it really gets expensive. And for a small business owner, that might not be feasible. So what do? A lot of the time, small business owners don't assert their claims. But when you have a registration, if you're able to recover your attorney's fees, that gives incentive to other attorneys, copyright attorneys, to take your matter on a contingency basis, because they know that if I win, I can actually recover my fees. Versus if you don't have a registration, you're not able to pay the legal fees, the attorney really has no incentive to take the matter on unless they're doing it from the goodness of their heart and it's a pro bono commitment. That's a separate issue. But otherwise, they'll just say that, you know what, this is not going to work out. I'm sorry, I can't help you. So it's not worth it. So for all of these reasons, a copyright registration is really, really important.
Amazing information. That's something that you might, we didn't know, never heard of that before. And the fact that you could even ask that to a lawyer to say, hey, I have a good case here. Are you willing to do something like that on contingency? Right.
Right. I didn't know that was a possibility, but it sure gives me a lot of ideas for things that I could be copywriting.
Exactly. Okay. So let's talk about the ever famous patents and what a patent is really used for. And tell us about that. And I think we all have thoughts that our grand idea is patentable, and what happens if it turns out it's not, and how do we move forward with that news if it becomes something that isn't workable?
Yes, so patents are kind of the gold standard of all IPs. At least that's what founders think. Right. But it's not really the end all be all. Even if something is not eligible for patent protection, you can still make a successful business out of it. So recently, I was at Alibaba's Co-Create conference and I was sitting in the pitch competition. So the last day of the conference was the pitch competition. And one of the very first things that these contestants were being asked by the judges, there was Lori and Damon John from Shark Tank. So they were there as well. And just like in Shark Tank, they were asking similar questions to the contestants. And one of the very first things was, what do you have that's proprietary? Do you have any proprietary protection? Do you have a patent on this product that you're trying to build? So every founder was so excited to talk about their patents, that yes, we have a patent pending, or we got a patent, or no, but we are in the process of getting a patent, because that was so important to all of these investors to see that, okay, is there actually something in there that we can successfully invest in that is actually novel technology?
Sure.
So that is what patents essentially are. Patents are reserved for products that are in the realm of inventions, technological innovations, even with, if you're in bioscience or biochemical, it could be different types of gene variations that are manipulated by human beings. So it's something that cannot occur naturally, but it can be manipulated by human beings. So you have all of these different types of products that you can get a patent for, but the core ideas are the same and the core requirements are the same across the board, and the same test is applied to every product. Is it new? Is it something that has not been done before? You can also do improvements on existing technology, and that can also be eligible, but that is the requirement. It has to be new or novel. It has to be non-obvious. So it's not something that can be easily figured out by an ordinary person. If it can be easily figured out, then that's not eligible for patent protection. So it has to be non-obvious. Then it has to be something that does not happen in nature. So it cannot occur naturally. There has to be human intervention to make it. So that is why, for example, there's a lot of GMOs, GMO-derived strains that are patented, because you might think, oh, that's an agricultural product, like why should that be patented? But it is, because without human intervention, you would not have genetically modified products or anything like that. So you can patent the, yeah.
I wouldn't have thought about that, but
it's something that can be patented. So anything that does not occur naturally. And finally, it also has to be functional. So it's something that cannot just be ornamental. It has to be functional, useful as well. So you've got all of these requirements for a product to be patent eligible. So as you can understand, not every product is going to check off all of these 4 boxes, and that is totally fine. But if you do have a product that you're creating and you think, I think I check all those 4 boxes. I made it myself. I've never seen anything like this in the market. I've done my search. This is a unique technology and it is useful. Okay, 100% speak to a patent attorney, run a prior art search to see what other technology is out there so you can pursue your patent. Or if you find out that, well, there is other technology that could be a little similar to yours, so it's not like you're coming up with brand new ideas here, then you have that information. You can go back to the drawing board and work around that patent or create something that is now truly unique. So when it comes to patents, you have to have a partnership with an attorney or a patent agent that can help guide you through the process. That, okay, let's do a search. Let's see what can be protected with patents. And something important to remember also is that one intellectual property element can have multiple layers of protection. So if you think you have an IP asset, like a product design, that can be protected with both patents and copyrights, because they're both looking at different things. Copyrights, ironically, just the opposite of patents, are not granted when something is functional. Functionality, okay. If you can show functionality to a copyright agent, Copyright Office says, no, you can't have it. And on the other hand, when it comes to patents, you want that functionality or that usefulness as well. So the same product design can have different elements that can be protected with copyright and can be protected with patents. So that's why there are a lot of times when I work with founders, I tell them, even before you go into patents, consider getting a copyright. It's a low-hanging fruit. It is less intense than patents. It's less expensive, but it gives you a broad protection coverage. So at least you can enforce it and you can show investors. So we work with a lot of startups that raise funding. And I know that one of the very first questions they will get asked is, what do you have that is proprietary? What do you have that your competitors don't have? And that's an IP question. And so you should be able to lay it out. I have these registrations. And even if your your product in the current variation or in the current version, is not eligible for patent protection, you can still get a provisional patent while you're improving on the technology. And when you have a final end product, that is when you can go for a full patent. But you can still get a provisional patent while you're still finalizing your design.
That's so interesting to know. You mentioned something called a prior art search. Is that something that people can do on their own, or do that have to do that through a lawyer?
Prior art searches are very technical. You have to work with a professional. It's not something that you can really do on your own. For trademarks, you can run a knockout search. So if you're trying to do a search on your own, I recommend that to founders, actually, that you do run a basic search. You cannot run a comprehensive search. That's what law firms do. We run a comprehensive search on the trademark name, but you can still do like a basic search on uspto.gov where you type in your brand name and see if you get back any exact hits. And that's a good thing that you can do. But when it comes to patents, prior art searches are very technical. It's not something that even I do myself. I have experts who are part of my team that run those searches for patents.
Wow.
Okay, so let's go one step further then, right? It's not a patentable product, but maybe it's eligible for trade secret. Can you explain what that means?
Yes. So trade secrets are a very, very special type of intellectual property right? And it is something that is the exact opposite of all of the IP rights that we just discussed. So for every IP right that we just discussed, the importance of registration is very important. Mm-hmm. Importance of registration is very important. Wow. That was like...
It's been a long, it's not your fault.
No. Long afternoon.
But with, it's one of those afternoons. But for trade secrets, it's the exact opposite. A trade secret is essentially intellectual property assets in your business, which is data, confidential information, something that is so sensitive that if it actually is made public, your business will lose its competitive edge. And so a great example of trade secrets is recipes. So KFC recipes, Coca-Cola recipes. We were talking about Nando's recipes, the sauce, the peri-peri sauce recipe earlier. Recipes are a great example of trade secret. Trade secrets can also extend to any kind of data that you have in your business that gives you a competitive edge. So that could be your customer list, vendor, supplier list, manufacturer's list, any connections you have, any network, business strategies, marketing strategies of your company. These are all trade secrets because if it's made public, your business will lose money, will lose revenue. There could be copycat versions of your business. So the way you protect trade secrets is the exact opposite way that you would protect any of these other IP rights that I just talked about. You need contracts, so strong NDAs in place and strong protocols in place to protect trade secrets. So contracts would be your non-disclosure agreements, other types of, if it is enforceable in your state. In California, it's not, but if you are in one of the states where non-competes are enforceable, you can do that. And also have protocols in place where only a limited number of people in the company has access to that information. to that specific trade secret. So if everybody in your company knows about it, that's not a trade secret. That's not going to make the mark. And a court will say, yeah, that's not how trade secrets work. Everyone knows about it. It's an open secret, but it's not something that you can protect as one. But only when you have a restriction on the number of people that has access to it, and also protocols in place where how they transmit that information, those are considered trade secrets. And for violation of trade secrets, you can get massive damages. You can sue people. You can halt their businesses. If like a former employee took your marketing strategy, went to a competitor and started working for them with those strategies, you can stop that from happening. You can get injunctions in court to stop launches, product launches, things like that. So it's very, very powerful. And so if you think that you have a trade secret in your business, definitely create the environment where that trade secret can be protected, and you have documentation to show how you're protecting that trade secret. So if there's ever a lawsuit, you can say, yeah, out of the 10 people in my company, 2 people know about this, 8 people don't. So clearly this is a trade secret. So that's just an example.
So, I mean, this is just furthering how, like, the importance of being protected, right? It's for all, it's like, kind of feels like insurance. It's like for all the what ifs, right? It's like for the what ifs that happen in life, in business, making sure that your brand, your idea, your product is protected. So when we think about, a lot of our listeners are startup founders, right? They're just getting their footing. They're like, and now I need to find budget for this, right?
It seems overwhelming.
It does. So I'm curious, like what would be your approach, or if a product-based founder is coming to you, what is your suggestion? How do they take what budget that looks like, and then whether it's stretch it out, or what are those first steps to making sure that they are protected, but that they also know maybe what's ahead of them?
I love that question. Yeah. There's a lot of planning and strategy that goes on when we are structuring IP portfolios. So something that is important for one founder might actually not be that important for another founder. So when you are starting out, I would say that if you're not VC funded, or you don't have funding, or you're bootstrapping, or you don't have, we have founders who are in successful 9-to-5 jobs, and they use their income from that job to fund the business. So, there's that as well. But if finance is an issue as a small business owner, then at the very least, what you want to do is book a consultation with an intellectual property attorney who specializes in your industry. That's also important because you want the attorney to understand your industry so they can advise you accordingly. And at the very least, this attorney will be able to look at your business, at your sometimes pitch decks. We even look at pitch decks, but we'll be able to look at your business and give you a game plan. This is the roadmap. This is what you need. And this is what would be great to have, but it's not a need at this point. And that way you have a checklist of intellectual property protections that you would need to get along the way. But an important thing to remember is that not everything needs to be done at once. So I think that is where founders get very overwhelmed that, oh my God, I need to do a trademark, a patent, a copyright. This is so much. I need to do contracts. And, they just go into a zone where they're like, no, you know what? I'm not going to do any of it.
I'm just not going to do anything.
And yeah, just like, okay, I'm just going to, shut my ears. This is too much. I'm getting overwhelmed. I'm not going to do any of it. But that's not the approach you want to take, because you can prioritize what is most important to you at this point. And it might not be the same as your friend who also has a product-based business. And that is also important to understand. A lot of the times I'll hear founders say, okay, I hear what you're saying, but let me talk to my mastermind group. Okay, fine. Talk to your mastermind group. Then they come back. I talked to my friends, and they said, actually, instead of a trademark now, I should be spending my money on patents. Because why? Because patents are important. That's great. Maybe it is the most important thing for them, but in your business, you don't even need a patent. You don't have something that can be protected with patents. So why would you waste that money, right? So everyone's situation is different, and you want to talk to a professional about it. 100% talk to your friends and brainstorm what would be the best thing to do, but follow the advice of a professional and then budget accordingly. Okay, I need to do this first, then I need to do this second. So maybe I can come back to this in 6 months. I can come back to this in a year. But the very first thing that, regardless of your business type, I always say is you trademark, because it's one of those foundational things that if you get this wrong, everything else just will fall. It's like you're building a house and your foundation is weak. It's going to fall. If you get a patent for your product, you send it to manufacturing, you stamp your logo on it, turns out that logo you can't have. Great. Now what do? You need to rebrand. You need to order new inventory. You might get your account suspended, because that's also really important. Like if you are a business owner that's starting out and say you want to go on Amazon, you want to be an Amazon seller, you need to get on Amazon's brand registry. The first requirement they have is they want to see your trademark application certificate, application receipt. They don't need a registration, but they want to see you're getting it because you have to be part of the brand registry. So when you can start selling on Amazon, now you can generate more revenue. Maybe you put that towards your patent. Now you put that towards your copyrights and other things. But that is your foundation. You do that first, and everything else you can plan out. Also, sometimes you can also budget and be smart about what kind of IP rights you're getting. If you have a logo that has very interesting design elements in it and it's just not plain fonts, then it could be eligible for copyright protection. So maybe right now you don't have the funds to get a trademark registration for both your name and your logo. But for copyrights, most of the time you will have the funds in terms of prioritizing, because copyrights will cost less. Okay, now if your logo has those design elements, your IP attorney can advise you that, okay, instead of going for a full trademark, for now, let's do the copyright for this. So you have a degree of protection. And as we discussed, copyrights can be very, very powerful. They are small but mighty. They can really land a bite. So you want to have that protection so you can go into production, you can do some of the work while you are, again, saving for your next investment, which would be the logo trademark. So your IP attorney can guide you that way, so you are maximizing on whatever budget that you currently have. And something else to also keep in mind is don't look at intellectual property protection only as protection. It is an actual asset in your business that has monetary value. So if somebody is coming in, if someone's coming in and looking at your business and tries to get a valuation of it, they're essentially giving a valuation for your intellectual property. If you have a patent, that will significantly increase the valuation of your business, because now they can buy something that is proprietary that nobody else has. If you have a really strong community, for example, if you are a social media driven brand where community is a big part of your marketing strategy, okay, that means your brand has a lot of value. So if someone wants to acquire the brand, they're going to acquire your trademarks. Otherwise, what is there to acquire, really? So think of it that way, that these are all assets in your business that actually have monetary value assigned to it. So if you ever want to exit, you want to sell the business, you actually have something to sell, which would be your IP. And I've seen such phenomenal acquisitions. So we work with our clients on acquisitions as well, and I've worked on both sides. One of my clients' trademark got acquired for $500,000, one trademark.
Wow.
And he was even barely using that trademark, honestly. So that's the power of having these intellectual property assets in your business, because if somebody wants it badly, they are going to pay top dollar to acquire it. But if you don't have these registrations, you're not really competition for anyone in that sense. So they don't really need to acquire anything from you
they can just do it on their
start
own.
doing their own thing.
Yeah.
Yeah. And they don't need you in that sense.
That's really interesting to think of it as like an asset.
Mm-hmm. I know our brains are spinning over here. We're just like,
also for like, like I know, like, and even when I was talking about it, I was just thinking about all of our clients. One of our clients built a 7-figure revenue source just from licensing out their trademarks and copyrights. That was the entire, that's a separate revenue source that they created because the brand was doing so well that people wanted to collaborate with him. And he said, okay, I will give you permission, but you need to license from me my brand name and the copyrights. And then that was a 7-figure revenue source. So there's immense power in what you're creating.
Amazing.
I'm so impressed. Like there are so many angles and considerations and opportunities because before talking to you, I really did think you had to do just this one thing, or for a product-based business, you could never do this thing. And all of that is very different. And I'm thinking about my brand and the assets and the products and the branding and all of that stuff in a different way.
Yeah, no, I think that's great advice. So, takeaways here, even if your budgets aren't big, spend the money to learn. Knowledge is power. We always say that, right? So spend the time to sit with a professional, understand what the runway looks like. I love how you broke it out to say not everything is needed all at once, right? You can pace it out for your business, but know that at the end of the day, understand the full spectrum of the opportunity, right? Not just this cost, but it's this opportunity that you have in building your brand. I think is such a great way to look at it. So as we segment out of this amazing podcast, we're definitely going to be coming back with episode
a part two.
Part two for sure.
Nuzayra also does contracts and all sorts of other things in this industry that we think are phenomenal for our listeners to hear, but it would be too long of
we'll come back because she does a lot of cool work with influencers and brand partnerships, which I think is definitely something that our audience would love to hear about. But as we think about, your business, your firm, right? How can our listeners work with you? Who's the best clients to speak with you? Do they need to be already in business? Are you open? Does the conversations for those consults we were talking about, like, is that something that your firm would do? Obviously, you're very well versed in the product space, right? And that's most of our followers and listeners here. So love to understand, like, how can they partner with you? Who is the right customer to kind of reach out?
I love that question. So I know I should have like an ideal client avatar. But honestly, at my firm, I started the firm in 2020. And when I started the firm, we worked with very small business owners, folks that were just starting out. But those same clients that were just starting out, and I was starting my own firm at the same time, they've now become multi-million-dollar brands, and they're averaging in $20 million in revenue, and they're doing amazing brand partnerships. But even till date, we still work with small business owners. So we work with business owners on both sides of the spectrum. We have clients who are just at the concept stage that come to us, and I will help them plan out their IP portfolio. And definitely they can't do everything at once, but they go away with that roadmap and they start with something that they need right now. So that is important. And also something at my firm that as a culture that I have created and I'm very, very passionate about is that I don't really just focus on the legal side, but when I'm advising on the IP portfolio, I'm thinking as a CEO myself. I'm a business owner and I don't like waste in my business. So I don't like to advise my clients to get something or do something that really doesn't translate into any ROI. So for small businesses, we will advise them on where to get started, what does the growth strategy look like for them, and they work with us more on one-off projects. So they'll come to us for a trademark, a certain copyright or a certain patent, and we'll help them with that. Or they have a certain brand collab they need to do, we'll advise them on that. And then on the other side of the spectrum, we have clients who are doing amazing. They already have established brands and their needs are very different. So they're looking more for strategic support and constant support. And so for clients like that, what we focus on are advice and strategy related to acquisitions. So if they want to acquire new brands, or they want to sell off their own assets. And also we heavily are involved in TTAB oppositions, which is Trademark Trial and Appeals Board opposition. So we handle litigation as well. So we defend our clients' intellectual property portfolios and also prosecute on their behalf. So we do all of that. And for these clients, we have more of, we are launching this program called Fractional IP Counsel. We would offer them our fractional IP counsel services, which is more of continuous support. So we have a monthly subscription plan, or someone can, our clients are sometimes on 6-month retainers or an annual retainer, and we provide them with continued support. So it just depends on what stage of business you're in and what level of support you need. If you need just project-based support, we will do that. And if you need more comprehensive, because you're growing, you're scaling, you just have 10 contracts that need to be reviewed in, in one month or 2 months, then you'll switch over to that. Yeah.
That's good to know, because I think that starting out, a lot of totally new startup founders think of working with a lawyer as like very intimidating, very scary, and they're gonna have this like huge monthly retainer. And it's nice to know that like you can piece together, get a consultation, do a project-based approach so that you can move at the speed that you're comfortable with when you're just starting out.
Yeah, that's great. Well,
Correct,
there
yeah.
has been so much amazing information. Nuzayra, thank you so much, not for recording just once, but twice with us here due to technical difficulties, but we appreciate it. I know our listeners have gleaned so much information. We're going to make sure to drop your information, your website in our show notes. Also, if you are not currently on our email list, you should join. There's going to be a great email information about Nuzayra, anyone that we're interviewing or talking about on the podcast, our favorite platforms or tools. It's all coming out in our email as well. So be sure you join that. And if you love this episode, we ask that you like,
subscribe, comment,
share,
all of the things.
All the things. So thank you again so much for being here, Nuzayra. We are so excited to have you, and we're going to have you back for way more content.
Absolutely. This was really, really fun. I had such a great time. And hope to be back on the podcast again.
For sure.
All right. Thank you so much for your time again. And we'll chit chat soon.
Sounds great. Signing off here on the Sourcing Gals.